When a case goes up on appeal to the circuit court, it's not a new bite at the apple. Even whether they would make the same decisions that the trial judge did on certain objections or evidentiary issues, it's not really a question of whether they agree with the trial judge. Then what? Is it over? No. There is still something that can be done. Hello again. It's Lana Manitta from Rossen Law Firm, and I'm going to talk to you today about post-conviction proceedings in federal criminal cases. And before we get started, remember to like and comment on this video, and please subscribe to our channel. We provide a vast library of informative videos on topics of criminal defense in state courts of South Florida and federal courts. So what can you do if you're convicted of a federal criminal offense? It's a pretty awful situation to be in, but it's not over when it's over, right? So I'm going to talk to you today about specifically post-conviction after a trial. We're not talking about conviction by a plea agreement, because in most cases in a plea agreement, you're going to waive a lot of your post-conviction options. That's part of the bargain usually. And so we'll cover federal plea agreements in another video because there's a lot that we can talk about there. But today we're focusing on a conviction after a trial, being found guilty by either a jury or by the judge if you have a bench trial. So the first thing after conviction at trial that your attorney needs to be thinking about and researching, and if appropriate, drafting and filing, are motions for a judgment of acquittal and or a motion for a new trial. Now, in this video, I'm not going to get into what we'll call the weeds about the procedural differences between those two things. But suffice to say, these can be filed as two separate motions, and at the very least, they should be sought as separate grounds for relief in the same motion. In other words, your lawyer should attack on both fronts. In seeking a judgment for acquittal, you're basically challenging the integrity of the verdict. You're laying grounds that the verdict is either unsupported by sufficient evidence, or it was the product of some error that occurred during or affecting the trial, so as to bring the integrity or the correctness of the verdict into serious question. It could be a violation of Brady, which is the government's obligation to provide exculpatory evidence. It could be juror misconduct. It could be newly discovered evidence in that short time between the conviction and the post-trial motions. Or more likely, it's going to be maybe a prejudicial ruling that was made by the court that, brings the integrity of the juror's verdict into question. Jury instruction, or maybe the way the court answered a juror's questions. The examples of what can be grounds for this motion are really only limited by the facts and circumstances of a particular case. And so, a good federal criminal defense attorney not only knows what to look for, but is thinking about these motions while the trial is going on, and while objections are being ruled on, while jury instructions are being given, during the jury instruction conference, while you're arguing why certain words should be used in instructions as opposed to others. If these arguments are not being granted, or objections are being overruled, these are things that have to be considered for post-trial motions. These post-trial motions may be re-raising objections that were, again, made at trial, and arguments that were made in the Rule 29 motion that is made for a directed verdict at the close of the government's case and the close of the entire case. When these motions, these post-trial motions, are denied, and I say when because in most cases, these motions are denied. Really, in the overwhelming majority of cases, these motions are denied, but they are appealable, and they provide distinct additional grounds for appeal, just like your Rule 29 or your motion for a directed verdict is appealable. And you're preserving these arguments by making them in these post-trial motions. So it's important to continue to litigate these issues even after sentencing or after the verdict. Now, once all of your post-trial motions have been exhausted, the next step in the post-conviction process is the appeal. An appeal it must be filed within 14 days after the judgment. Most people note their appeal orally at sentencing, but you still have to have a formal notice of appeal filed. Counsel should be taking care of that. Even if your attorney is not going to represent you on your appeal, some attorneys don't do appeals. If they're not going to represent you on the appeal, it is still the responsibility of trial counsel to note that appeal for you. They can always let the appellate court know that they're not going to be handling the appeal for you, but that is still a part of the responsibility that is on trial level counsel to make sure that your appeal is preserved in every way, including noting the appeal, meeting that deadline with 14 days after the judgment. I usually do it within the 14 days after the actual sentencing hearing, even if the judgment and commitment order has not issued, because I don't want to lose track of that deadline. Technically, the judgment and commitment order may not be entered for a few days, or even in really rare cases, a week or so after the sentencing hearing. But that's dangerous because you can lose track of that 14 days if you don't know when the judge is actually going to sign and enter that order. So I usually do it within 14 days of the sentencing hearing. If it turns out that the judgment and commitment order hasn't been entered before I file my notice of appeal, it's okay. Better to do it early than do it late, and it will simply be held in abeyance until the judgment and commitment order is entered. So it's totally fine to do it that way, and I think it's actually safer. So once the notice of appeal is filed, that is going to open up the case at the Court of Appeals. The courts of appeals in federal court are the circuit courts. So in where I do most of my practicing up in the Eastern District of Virginia and Washington, D.C., we're dealing with the D.C. Circuit, the Fourth Circuit. Here in South Florida, our federal courts are part of the 11th Circuit. So when a case goes up on appeal to the circuit court, it's not a new bite at the apple. It is not a new consideration of the case. The Court of Appeals doesn't look at everything that happened and consider the whole case again and sort of retry the case. Even on paper, it is not a retrial of the case. And I think a lot of defendants really have a misconception about what can be done on appeal and what's appropriate to argue. And sometimes this causes a tension and frustration between counsel and client because counsel can't make the arguments that a defendant wants to make on appeal simply because it's just not appropriate. It's not something that can be made on appeal. So I think it's really important, even if your federal trial defense attorney is not going to be handling your appeal, that they are nonetheless educating you while the trial is going on, even before the trial, as to what might be appropriate for appellate consideration later on, sort of setting your expectations, educating you on how appeals work so that even if they're not handling your appeal, when that case gets handed over to your appellate counsel, you know what to expect and you can have productive conversations with your appellate counsel rather than what often happens is that first whole phase of the appellate process is, I don't want to say arguing, but having some challenging discussions with the client about what is actually going to be, able to be accomplished and able to be argued on appeal. It really can lay the groundwork for a troubling relationship with appellate counsel if a client is not adequately educated before we get to that point as to what is really involved in an appeal. So I'm going to try to give you some of that education now, but it really is important when you're looking for federal criminal defense counsel that if this attorney is not going to be able to handle your appeal, which is fine and it's common, that they know what federal appeals entail and they're going to be educating you throughout your trial level or even plea level process, what you might expect post-conviction. And it would be helpful if they can refer you to somebody that can handle your appeal, but at least educating you. So, as I said, the appellate court, the circuit court, is not going to consider your whole case anew. They're not going to look at the entirety of the case and decide whether they would, for instance, decide the way the jury would, or whether the jury was right, or even whether they would make the same decisions that the trial judge did on certain objections or evidentiary issues. It's not really a question of whether they agree with the trial judge. The appellate court is determining whether there was error. And error is defined much more narrowly than I would have done it different. I think you made a mistake. It doesn't work that way. It has to be error as defined by the law. And even if error is identified, the appellate court has to decide whether it is the type of error that is reversible error, meaning they will reverse the decision of the trial court and maybe send the case back to the trial court to either fix their error, or if it's so significant, there has to be a new trial. But you can have harmless error. So you can have an issue where the appellate court says, yes, the trial court did make a mistake. They committed error. But it was harmless. It didn't actually affect the decision that the jury made or the ultimate decision that the judge made at a bench trial, because there were such other factors or such other circumstances that there would have been the same result. And that's, a really sort of Pyrrhic victory, we call it, on appeal, when, you're able to successfully argue that a mistake was made, but the appellate court can find that nonetheless, it didn't really make a difference. And that happens quite often. So how is error determined? It's determined based on precedent. Precedent are cases that came before. And precedent from the Supreme Court or from the circuit that you're in is controlling precedent. That is controlling law that the current court has to look at and follow on that particular subject. If there is no controlling precedent, the court can decide that issue for itself, based on its interpretation and application of the law, the statutes that are applicable, common law, constitutional law, and also can look at guiding authority, which is from other circuits. Now, it's important, therefore, for appellate counsel to not just submit a brief that argues every little thing that the defendant thinks went wrong at their trial. It's really important that appellate counsel is focusing on the best issues, the issues that are likely to be successful. True error, reversible error, error that made a difference, and that is significant. So the biggest issue that comes up when we're dealing with appeals is clients want to appeal because witnesses lied, right? That's what I want you to say to the appellate court. Well, that's really not grounds for appeal per se. You can have an appeal argument that there was insufficient evidence to convict, but not just witnesses lied. And here's the problem. Appellate law is really well settled that the jury or the judge in a bench trial is in the best position to determine witness credibility, because they're there, they listen to the testimony, they watch the witness on the stand, they watch their demeanor, they hear the tone of the responses to cross-examination. And so their determination of whether a witness is lying or not is given, almost complete deference by an appellate court. So an appellate court is not going to substitute its own judgment on whether a witness is telling the truth, almost regardless of how good an argument you can make on appeal for the inconsistencies that were brought forth at trial. It's very, very unlikely. If the jury heard the witness and your attorney made these arguments about inconsistencies at trial and you're still convicted, that's going to be good enough, by and large, for the appellate court. They're just not going to second guess the judgment of the jury. And that's why sufficiency of the evidence, especially based on witness credibility, which most defendants think they think it's the best argument on appeal, right? I shouldn't have been convicted. There wasn't enough there. The witnesses lied. It's most common what defendants want to appeal on, and it's actually usually the worst grounds you can have. Generally speaking, it's put last in order of argument in the brief, and it takes second priority to arguments that involve rulings of law that might be very, very discrete, very narrow issues, but are much better issues, much more ripe for review and reconsideration and reversal by an appellate court than sufficiency of the evidence. So in some cases, rulings that the trial court made are reviewed anew. They call it de novo. In some limited cases, the appellate court is going to look at that really narrow issue and decide it for themselves with no deference to the trial court. If you have issues like that, constitutional issues, interpretations of statute, things that the appellate court is going to decide for themselves without deference to the trial court or to the jury, those are the arguments that you want to be making first. Whereas other rulings are reviewed under an abuse of discretion standard. And just like it sounds, it's really deferential to the trial judge because the trial court is only going to be reversed if the ruling abused the court's discretion with respect to those kinds of decisions. Okay. And that's a pretty narrow class. It's hard to meet the standard of abuse of discretion. So what happens after your appeal? Your appeal to the circuit court is denied. There are a couple of petitions that can be filed still at the circuit court level, seeking a rehearing by that 3-judge panel or a rehearing en banc by the entire panel, basically asking for a reconsideration of the decision. And if these are then denied, you're looking at filing a petition for a writ of certiorari to the Supreme Court of the United States. This is not something that you can do in every case either. There are limitations according to the rules as to what qualifies for a petition for cert. I'm not going to get into that. This could be a whole other video. But assuming that, your appeals have been denied, the Supreme Court says, no, we're not going to hear your case. It's called granting cert. We're not going to grant cert. It's very, very rare that they do. Then what? Is it over? No. There is still something that can be done, including what's called often a habeas petition. It's really a petition under 18 U.S.C. 2255 that's seeking a vacation of the conviction or the sentence. It's going to be a claim that really the imprisonment is unlawful because the conviction or the sentence imposed was in violation of constitutional rights, for instance. Or now we can prove actual innocence because of newly discovered evidence or a newly discovered Brady violation. This is a whole new litigation. It's got a separate case number. It's actually a civil case, and it starts a whole new process with appeal to the circuit court and petitions for cert to the Supreme Court. It starts basically a whole new calendar of post-conviction work. And aside from these two really robust bodies, appeal and habeas, there are also motions for compassionate release that can be filed based on extraordinary and compelling factors that might warrant a reduction or early release. There are Rule 35 motions that can be filed only by the government for substantial assistance. And there are even subsequent 2255 petitions that can be filed if the circuit court gives you permission to file a second one or a subsequent one after the first one has been completely adjudicated. So the point is that a criminal case in federal court does not necessarily end with conviction. There are other types of litigation. They're slower. They're more methodical. They're usually all on paper. They usually don't have any oral argument, and they require skilled counsel who knows how to do post-conviction work, who knows how to research, who knows how to write effectively and argue on appeal, both in writing and orally if necessary. And be prepared to tell their client, that's not grounds for appeal, and to deal with the frustration that's going to come from the client, really understanding how to thread the needle on appellate work and post-conviction work, and that, we can't just throw the kitchen sink at the appellate court or, make every argument we made at trial all over again. So it's really important to have an attorney that you trust, that knows what they're doing, because oftentimes in criminal defense, and especially in the post-conviction arena, you're really going to hear things that you don't want to hear. But you need to know that you're getting the right advice. So I've given you really just a small snapshot of post-conviction work that can be done on behalf of a client who's been convicted in federal court. But the first step, of course, if you're facing criminal charges or someone is facing criminal charges, is to avoid that conviction altogether, hiring experienced defense counsel to fight the charges with everything they've got, like the attorneys do here at Rossen Law Firm. But if things don't go your way, at trial, the fight doesn't have to end. So like and comment on this video, subscribe to our channel, let us know what else you'd like to learn about in the world of federal criminal defense or state criminal defense before the courts of South Florida. And if you need us, call the Rossen Law Firm today. Thanks for watching.